to a firearm.
I remember the trial testimony very well.
Right. And
That the court could consider the evidence presented at trial for the purposes of determining whether there was a willful and substantial violation of probation. Correct?
that's correct.
All right, very well. So what I'd like to do is, before we get started on the sentencing, is just really quick. Now, Mr. Ball, and I'm going to go to the court file right now. My understanding is that in 2017 CF 11673, Mr. Ball was on probation for, I need to take a quick look at the judgment and sentence.
Your Honor, it's trafficking in MDMA and possession of a firearm by a juvenile delinquent.
Okay, and my understanding is that he was sentenced to a YO sentence.
That's correct.
Now, trafficking in ecstasy, is a first-degree felony punishable by up to 30 years?
That's correct.
Is there any kind of mandatory minimum?
Yes.
You know what that is?
I'm looking at that now. There's a $50,000 fine, and I believe it's double checking, but
My main concern is not the fine.
right.
My concern is whether there's a mandatory minimum prison sentence.
Double checking. I think it's 7 years, but I'm going to double check. I'm sorry, it's 3 years for the amount that he had. Right, so it's 3 years.
And a mandatory minimum for purposes of this offense is not a day for day like a firearm minimum mandatory. Instead, it's a mandatory minimum, which is a floor below which the court cannot go unless the court chooses to impose a youthful offender, to reimpose a youthful offender sentence.
Correct.
Does everybody agree with that?
Agreed.
Okay, very well. All right, give me 1 minute. Okay, and then everybody agree in 2018 CF 320, possession of ammunition by juvenile delinquent, found to have committed a felony act, it's a secondary felony punishable by up to 15 years in prison.
Yes.
Everybody agree with that?
For the secondary offense, Your Honor.
Right, and then that would be, so he would be subject to 15 years in prison unless I chose to reimpose a YO sentence. Everybody agree with that?
Yes.
Yes, Your Honor.
Okay. Do y'all want to be heard first on the BOPs?
Yes, Your Honor.
Sure.
Okay. Mr. Locondro?
Your Honor, briefly, I think that a jury found him by a higher standard of reasonable doubt that he was guilty of 9 felonies, including a life felony. I think that the lesser standard for probation,
Including capital.
including capital felony, right? I think under a lesser standard, the state certainly has met its burden of preponderance of the evidence. So I don't have much more to argue about that. I mean, there was certainly circumstantial evidence and also at one point identification of him perpetrating these crimes. His DNA was on a gun, or well, the court's well aware it happened a week ago, but his forensic evidence that also puts him at the scene of this crime, and he's certainly not allowed to possess a firearm, and the DNA was found on a gun light, which sole purpose is to affix to a firearm.
I remember the trial testimony very well.
Right. That's all I have to say.
Mr. Early?
The standard for BOP, although it's lower and different from the new law violation, it's willful and substantial. Based on the evidence in this case, Your Honor, the motions that were filed, and we'll reserve our argument for the appeals process, we would ask for the 2 BOPs if the court considers minimum mandatory for the first BOP and YO for the second BOP. He was sentenced as a youthful offender for both of the cases, and based on the court's calculation, Mr. Ball has been in custody since January 21st, 2021. That would count to 4 years and 17 days. If the court considers a min-man on the first BOP, that would be credit time served. For the second, the 15 years for the state prison, we would ask that the court sentence Mr. Ball with YO. In essence, for the first VOP and the second VOP, considering the time up until his arrest, there was no violations even after this alleged incident, that the court will sentence for both VOPs either the youthful offender or in the alternative, 3 years for both running concurrent and credit time served to in the probation of both cases.
Okay. All right. Would you have any objection if I rule on whether I believe by a preponderance of the evidence that there was a willful and substantial violation, if I ruled on the merits and held off on the sentencing until I hear any evidence you wish to present? Because although, I mean, what I'm saying is I'm willing to, if you'd like to, if you're going to present any sentencing evidence today, I can consider that for the VOPs too.
As far as mitigation, sentencing evidence, we did waive the PSI. There won't be any testimony other than one family member, and then any testimony we would reserve that. So in all candor to the court, there's not a substantial amount of mitigation for purposes of sentencing. My reasoning for the court getting rid of the VOP is twofold. Just so the court understands my explanation, there's been times that I've tried a case where my client was found not guilty, but then punished on the VOP. Different standards, it's at the discretion of the court. And then in this case, client found guilty, punished on VOP, again, different standards at the discretion of the court. But the reasoning for VOP is the amount of time that was spent pre-trial in custody weighed with the amount of time that the youthful offender would have elapsed. So strictly for VOP, knowing that there won't be substantial mitigated testimony, I think it's fair if the court continues to sentence for both VOPs under the YO statute, credit for any time served prior to the VOP, in addition to credit for time served after being in custody in 2021.
Okay. So what I'm hearing you say is that you don't really intend to put on a mitigation case, given it was a mandatory.
Exactly. Had the circumstances been different, we would have ordered the PSI and presented mitigation because the court would have more discretion in the sentencing. But just looking at it in its reality, it would not have made sense it would not have made sense to do it that way.
Okay. All right. So very well. Then I'm ready to roll. So let me make sure I'm in the right case. Okay. So in 2017-11673, I do find that the state board's burdened by more than a preponderance of the evidence to demonstrate that Mr. Ball willfully and substantially violated his probation as set forth in the violation report dated 02/02/2021. Was there a more recent one? Was there an amended one, Ms. Jenkins, before I proceed? I'm taking a look at the one that was filed on 02/2021, but I just want to ensure that there was no amended affidavit. Let me go into that.
I don't believe there was, but
Okay. There was an addendum dated 10/05/2021 I'm looking at 217-661163. There's an amended affidavit filed 10/05.
I see that one, that's the only one I
2021?
can see.
I want to make sure I examine the,
Yeah, that's the only one that I see, Your Honor.
okay.
I wasn't able to get this one.
I think the only addendum had to do with costs. So in 2017 CF 11673, I define, as I say, the state board's burdened by a preponderance of the evidence, indeed more than a preponderance of the evidence, that demonstrated willful and substantial violation as set forth in the violation of probation affidavit dated 02/02/21, as well as the amended affidavit set forth on 10/05/2021. And the amended affidavit of violation of probation did not include the additional offenses, so I'm not considering that for the purposes of the violation. The only offenses that were alleged had to do with first-degree murder and attempted murder of Mr. Poe. So understand that I'm only considering the allegations set forth in the affidavit and amended affidavit. I'm not considering anything that's not there. So I do, having found that the state has borne its burden approve, and having considered the suggestion by defense counsel that I reimpose a YO sentence, I decline to do so based on the fact that there's a substantive violation as opposed to a technical violation. As we all know, in YO sentencing, YO probation is a little bit different in that if there was merely a technical violation, for instance, failure to pay costs, then the court would be limited to reimposing a YO. Substantive violation, the only substantive violation of probation for YO is a new law violation. And so therefore, based on the evidence introduced at trial, having found a willful and substantial violation of condition 5 of the order of probation, specifically committing a new law violation, I am not going to impose a YO sentence. I believe that it's inappropriate to do so based on the circumstances of the new law violation. So as to count 1 in 2017 CF 11673, trafficking, I'm going to impose sentence Mr. Ball to 30 years in prison. On count 2, I'm going to sentence him to 15 years in prison. Revoke and terminate his probation. I'm going to run the sentences in counts 1 and 2 concurrently with each other. Insofar as credit time, as to counts 1 and 2, he'll get FSP time to be calculated by the Florida Department of Corrections, plus 1,500 days. So 30 years on count 1, 15 years on count 2, concurrently with each other. He gets credit FSP plus 1,500 days credit. All court costs, fines, and fees that were previously imposed will be reduced to a civil judgment. Insofar as the allegations of failure to pay costs, I am not considering those. The only violation that I'm finding is to the condition, which is listed as condition 5 in the amended affidavit, or the affidavit and the addendum, is the violation for committing new law violations. In case number 2018, I also, having found a willful and substantial violation by committing a new law violation, which is a substantive violation of probation, 2018 CF 320, I'll adjudicate you guilty. And by the way, in the 2017 CF 11673, the defendant was not adjudicated guilty. I will adjudicate him guilty in that case, as well as in count 1, if the defendant was not previously adjudicated guilty, and I believe he was, then he'll be adjudicated guilty, 15 years in the Florida Department of Corrections. He'll be entitled to all credit FSP plus 1,500 days. I'm going to run the sentence that I imposed in 2018 CF 320 concurrently with the sentence I just imposed in 2017 CF 11673, and vice versa. All previously ordered court costs, fines, and fees will be converted to a civil judgment, and the defendant's probation will be revoked and terminated. And again, in that case, the only violation I'm finding is a violation of condition 5 as set forth in the affidavit and addendum, that is committing a new law violation while on probation. All right, any questions about that? Mr. Locondro?
No, Your Honor.
Does that appear to be a lawful sentence?
Yes.
Very well. Ms. Irving?
So you're running for 2017-18, all counts 1 and 2, and both cases run concurrently, correct?
Yes. Concurrently with each other.
Based on the law? Yes. No objection, based on the law.
All right, very well. All right, so Mr. Locondro, would you like to present any victim impact evidence or any evidence relative to sentencing?
Yes, Your Honor, I have a few individuals that would like to speak. I'd like to start out with the victim, Anandi Wyche's mother, Monique Wyche, and if it's okay, if the victim advocate could accompany her.
Of course.
And the victim advocate is Mackenzie Roden.
Well, why don't we let her take over Mr. Locondro's spot? Something to lean on, necessary.
She doesn't have to sworn in.
And this is, Mr. Locondro, this is for the purposes of providing victim impact testimony, is that correct?
That is correct.
Very well. Good morning.
Good morning.
Could you, before you begin, could you please state your name and spell it for our court reporter, please, ma'am?
Monique Wyche, Monique Wyche.
Thank you. Do you have a statement you would like to read or provide to the court, ma'am?
Yes, ma'am.
If you are reading a statement, may I ask you to do me a favor? Typically, what happens is we read faster than we speak, and we want to make sure that the court reporter can get everything you say. So if you would use conversation speed as opposed to reading speed, it would be much appreciated.
Okay. All right. Nandi was loved by everyone. She touched her family, her teachers, her principal, Messages of her grace still find their way to me. One teacher even confessed she made her a better educator. She had a way with people, a unique, contagious vibrancy. She was known for her fashions, captivating confidence, masked by a humble demeanor. I still remember picking her up from school. Before she hopped into the car, she would be wrapping her warmth around 5 to 6 of her friends in heartfelt hugs. Nandi was that popular sweetheart. Loved by everyone, she was cruelly taken from us. The community was in shock, in shared grief and outraged. Many young people who crossed paths with Nandi shared she was their ray of hope and inspiration. My heart swelled with gratitude hearing their stories. If Nandi was living, she would be 22 years old, probably a college student at FAMU University. But fate cruelly decided otherwise. Nandi will forever be my 17-year-old varsity cheerleader on her journey to be crowned as Miss Joan Ribault, a graceful dancer, a spirited volleyball and tennis player, a student council member. Her life was extraordinary, profound, her spirit echoing in our lives. We celebrate Nandi, not her death, but her life which continues to inspire, motivate, lift up everyone who was fortunate enough to have been touched by it. Thank you.
Alejandra?
I believe one of her teachers, Ms. McNulty, wanted to speak as well.
Very well. Good morning.
Good morning, Your Honor. Thank you for having me. My name is now Renee Turnbull, Turnbull, but I was Ms. McNulty when I was Nandi's teacher. The year that we lost Nandi, I was the teacher of the year. Sorry, I didn't know it would hit right at the second. I adored her so much. She made the days easier at Ribault. She was a cheerleader and a volleyball player and a dance diva. She was at the front of the parade doing the steps first that the girls would follow. She was that girl, the fashionista. I wore my most colorful clothes. I wore all the colors of the wedding rings that I could find because that's who Nandi was. She was all the colors. And she was so kind. She led with kindness, not just with her beauty. All the boys wanted to date her, all the girls wanted to be like her, but she was humble. She would come into class. She wanted my math class, but my math class was full. So I had to teach an extra class, U.S. history, because the kids couldn't pass the EOC. So Dr. Bostic created an extra class, and we all had to teach some intervention. Nobody wanted to come to that class, and we all had to teach it. So Nandi had the buy-in, and she would have a good attitude. And she would come in, and she would sit by people that nobody would sit by. And she didn't do it like she was doing them a favor. She did it like they were just as great as anybody else in the room because that's what she believed in her heart. Because she was led by the Spirit of God and she knew we're all the same before Him. She wasn't doing anybody a favor. So I loved that Nandi would participate and then everyone would participate and then the whole class would perform better because she led them well. We were all better because Nandi was with us. And once a month, we did Wellness Wednesday, which was a mental health class. And you can guess how much all the nobody wanted to come to that either. And we would talk about bullying and talking about forever. But it so matters. You know, we're here today. How do we treat people? What do we do when we're offended? What do we do when we're wronged? And we talk about the balances. Andy would say, I was just another person, everybody. So those are some of the things that Nandi did and some of her character and some of her leadership. But the best part of Nandi was her spirit. We had to stand outside. You know, Ribault's an outside school. There are sidewalks, not really hallways all the time. There's a sidewalk. And we'd teach bell to bell. And then in 5 minutes, between classes, you had to stand out there so there wouldn't be fights. And you would do infraction detail, tuck in your shirt, are you wearing your belt, whatever the thing was, show your ID. And the kids didn't like it, and the teachers didn't like having to watch for the fights. But we did this, and then there would be Nandi. And Nandi was like this beautiful, fragrant flower that was all the colors. And she made it worthwhile to be outside. I looked forward to seeing her coming down that sidewalk. I would just breathe in that beautiful presence of God in this child, and I could go back in and have a better day. And I think about that song, This Little Light of Mine, I'm gonna let it shine. There was a light beyond Nandi's eyes that was brighter than her smile and her beauty and her dance and her clothes. It was that piece of heaven with us. The next verse says, won't let Satan blow it out. I'm gonna let it shine. And then it says, the world didn't give it, and the world can't take it away. Her light didn't get taken away. It got multiplied with us, and heaven just got brighter. It just went from here to there. I love my girl, and I miss her with all my heart. But heaven got brighter. She's still with us.
Thank you, ma'am.
Thank you.
Can you do me one favor, though? Could you spell your maiden name?
Yes, I'm sorry. It is McNulty. Thank you. Yes, thank you.
Mr. Alejandro?
Her grandmother Helen wanted to speak. She wrote something.
Morning.
Good morning.
Can you tell me your name, please, and spell it for me?
Helen, HelenWilson, Helen Wilson. I'm Nandi's grandmother. And it's all kind of love. But the love that you have for a grandchild is so different. I was told by my mother that that's how it would be. But when I first held my granddaughters, it was something, my heart just took half of it. I have another granddaughter. And then after I held Nandi, she took my heart. My heart is in two. My heart will never be the same. I will never be the same. Our family will never be the same on holidays and birthdays. She was a happy baby. And if she cried, it was something wrong. I know one time she was crying, and her mother took her to the doctor, and she had an ear infection. And it was something with her eyes. When you look into her eyes, it was like a light. Yes. She would just look at you, and her eyes would just sparkle. Her smile, she was so happy. And she loved the people. And even some of my senior friends, she would say, make sure you lock your door now. Did you take your medicine? And they would say, well, she telling me, I should be telling her. She said, that girl is looking after us, and she was only 16. She loved the people. She loved young people, old people, anybody. That was Nandi. That was Nandi. But she loved it herself. But her heart was better than her looks, her outside. She loved it her hair. She loved it her clothes. She liked the way she looked. She liked the way she walked. But most of all, she would just love. She had love for everybody. And like she would tell me, Grandmama, some of the girls don't like me, but I still love them. And I would say, don't worry, baby. That's all right. She was looking forward to voting. She said, oh, I can't wait till I get 18. I want to vote. I said, okay, you will. But unfortunately, she didn't. And she was looking forward to going to college, and we all was happy. And she told me, I'm gonna run for Miss Ribault. But first I thought she just was, talking. You know how little teenagers talk. But she was running. She was in the running. And she wasn't afraid to drive. When she first started driving, I said, oh, no, Nandi, I can't drive with you. I'm not going to drive. My nerve is too bad. And the first time I rode with her, it was at night. And I had my pocketbook in one hand and my heart. And I said, Lord, Nandi, I'm going to drive with you at night? Oh, my God. But she did it. She drove. And she loved it. She loved it her food. She loved it her hands and clothes. And that night, before she died, that Thursday, she came over and she had some French fries and she wanted to feed me. I said, no, I don't know whether your hands clean, but like a grandmother and like love, I let her feed me French fries. And we had this saying that I would always, she said, I love you, grandmother, I said, I love you. And when I would see her, she would hug me so tight until sometimes I had to pull her hand away. And I said, but Nandi, I love you more because I'm the oldest. And we always say, I love you more. And I said, I love you more. I love you more. We would go back and forth like that on the phone, or sometime when her mama would bring me back. And that Thursday, she came over. And I don't know, it was about 12 or 1. And she said, I'm going home. So I said, well, come back tomorrow and get the money for your, the Ribault package, for the putting the books. And that was the last time I saw her. And the last thing she said, she walked down our driveway, and I told her, I said, I love you more. She said, I love you more. And that was it. And then that night, Friday night, that later on, they called Thursday night and said she had got shot. And I didn't believe it. And my life have never been the same. And it will never be the same no more. Christmas, holidays, Thanksgiving, nothing will be the same. My life have changed upside down for the love of my granddaughter, Anandi.
Your Honor, I think that concludes everyone that wanted to speak. So.
Very well, thank you. Any other evidence you wish to present?
No, Your Honor.
Okay, very well. Ms. Wood?
Yes, Your Honor, we have the incidents of Mel Harvey, that's Mr. Ball, older sister, Ms. Harvey, or, can you hear me? You can unmute.
Are you calling on me?
Yes, ma'am. Can you hear me okay?
Yes. Yes, I can hear you. I can't hear KC really good on this end.
All right.
Yes, ma'am?
Can you raise your right hand for me, please, ma'am?
Is this better, can you hear me?
Yes.
Okay.
Yes, I can hear you.
You solemnly swear or affirm the testimony you give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Okay, so I apologize, Ms. Harvey, just state your first and last name for the record. I know that you got married, so I see a different name at the bottom.
Romel Viola Harvey, recently Romel Viola Greaves.
Okay, you may address the court. And just, how are you related to Mr. Ball?
I'm his sister.
Okay, you may address the court at this time.
I first like to say that I think the judge, I've heard great things about this judge inside the court and the people who work there, that she's a fair and honorable judge, so I thank her. I thank you, KC, you've done a great job. I'm very pleased with how the court system works and how everything works. Of course, I'm not pleased with the outcome, but I'll tell you a couple of things about my brother, Roland Ball II. A lot of things that the court didn't say is that he's first a child of God, second, the child of Marcella Joyce Harvey, which was a fierce woman that died on March 14, 2014, while these proceedings were going on. After the first initial lawyer that we hired walked away from the case 2 days, she dropped dead from heartache. I'll say that, and then I'll go on to say that he's a father of 3 kids, 6, 5, and 3, 2 daughters and a son. And as I hear the testimonies from the other people from Anandi, my heart goes out to her. I'm that same girl. I was that same girl, going to FAMU, went FAMU between 2004 and 2006 with so many, and I relate to her so much, and my heart goes out to the family, deeply. I see her, I can relate. And a lot of times, us young women from these neighborhoods get with guys, and we're wonderful black magic queens getting with these guys, and we don't know what we're doing. So my heart goes out to that family so much, because I see her, I see it, and she was a wonderful girl. She was, and probably would have went on to do a lot of great things. Let me regroup. She would have went on to be a wonderful girl. So I sympathize and I empathize so much with her family. I do. I was that girl too. Trust, I was. So I understand. But my brother, Lamar Ball II, my favorite, I'm the oldest of the 4. I'm 14 years older than him, 10 years older than my sister, and 16 years older than my younger brother. I'm the second mom. I know him. He is a good person. No matter what has been said, he's a good father, an upstanding person, my favorite of all the siblings. He has a true heart. He would Never. So I say this. Lamar, that's what I call him, his middle name, because it's 3 of them now. It gets confusing. Lamar is a child of God. He's a son, he's a brother, and he's a father of 3. 2 beautiful little girls and 1 son. I wish justice for her, I really do. I wish justice for her, and she deserves that. I do, and I hope they find that person and held to them. But Lamar Ball II, he is a great swimmer, he's an artist, he's a poet, okay? He's a logger, come to find out. He came up to his Seattle and chopped a lot of wood down here. He's a great football player, and he could be a lot of things. In my grandmother's eyes, he was called Senator Ball. So his future is already panned out for him by God, and nothing can disturb that. So I will digress. I thank you, and thank everybody else. Lamar, your family loves you, and we will fight into no more. Thank you.
Thank you, Ms. Harvey Greaves. And Your Honor, Ms. Harvey is the spokesperson for the family. There was a family meeting, and she had the ability to speak to the mother of Mr. Ball's children, Amari Platts, the family, and also just want to acknowledge his father, also a family member in the gallery as well. So I want to talk a little about the law. And
Well, can we stop a minute, please?
Yes.
So what you're saying to me is then you don't have any other witnesses.
That's correct.
Now, Mr. Ball, let me explain something to you, and then I'll let your lawyer tell me if you've made a decision on this, but I do need to tell you that in sentencing proceedings, you have 3 rights. You have the right to testify under oath, subject to cross-examination. You have the right to do what's called allocute. And allocute basically is where you would come up to the podium and just tell me anything you would like me to know before I impose sentence that's relevant to sentencing. Okay? You understand what I mean? Allocute is kind of a legal word, but basically it's just an unsworn statement that you would want to tell me before I impose sentence. And you know, and I know, that the sentence on count 1 is mandatory. In other words, I have no discretion but to impose a life sentence without the possibility of parole as to count 1. However, I do have discretion on the other counts, and therefore and I have to sentence you separately on each count. So I want you to know that you do have the right to allocute or to tell me anything you want me to know. The last right you have is to remain silent and let your lawyer speak for you and make an argument as to sentencing. And I will not hold it, just like the jury can't hold your silence against you in any way, I wouldn't do that either. So the fact that you don't make a statement will not impact me in any way whatsoever. But I do want you to know that you have those 3 rights. Do you understand that? I think we can hear you. You have a good, nice command voice, so.
I think you sent me 30 years of I don't have any license.
I can't, I'm sorry, I can't hear him. Go ahead.
You sent me 30 years on the DOP, and you no letter on the work, and then they probably tears. I think give you a license. Y'all, you really got me to say, I agree with family, and my family agree with me, but then it's a matter of the sentence. But hey, I really appreciate it.
Well, what I did was I did impose that 30 years concurrently with the sentence in 2017 and 2018. And by the way, I did forget, and Mr. Ball has not left the courtroom to begin his probationary sentence, but there's a mandatory $50,000 fine and $2,500 surcharge on count 1 in the 2017 case the law requires me to impose. All right, so thank you, Mr. Ball.
Since we went back on the VOP as a court, I know that the court mentioned credit for time served Florida State Prison for, did the court count the 2 years prison that was applied to the VOP? Just wanted to clarify the record.
So what I did was...
It was, okay.
I awarded Florida State prison time plus $1,500 days of jail credit. The Florida Department of Corrections will calculate his credit that he received for his prison time.
I wrote it down, but I just
can't do that.
No, I wrote it down, but I wasn't sure if that's what I heard or if that's what I'm used to. So I just want to clarify the record, but you did, thank you.
Yes, I did. I awarded FSP time plus 1,500 days for each of the two cases. And as I said, I ran those sentences concurrently with each other. I haven't yet made a decision on whether I'm going to run this one consecutively or concurrently, but I will do that at the appropriate time.
In addition to the
So
state,
if you're finished with evidence, I think the state has a right to go first on sentencing, and then you can go.
okay.
Because you said you finished your evidence, Mr. Ball is allocated. So,
Well, it was kind of, I know that Your Honor did the colloquy with him. This was more of just putting the case on the record as far as his right not to express any type of remorse. I'll just leave it for the closing.
oh,
It's
believe
fine.
me, I understand that, let me put it this way. The fact that he did not express remorse, I will not consider that in any manner.
Okay. And
Because again, I think under certain, the case law seems to be very clear that if the defendant allocutes, the court can consider that. However, I'm not going to. I'm not going to, as I told Mr. Ball earlier, his silence cannot be used against him anyway. He didn't address remorse one way or the other. I'm not going to consider, even if I were to consider his allocution as not expressing remorse, I'm not going to consider that in any way. So I don't want you to feel like you have to spend time on case law that I will tell you I'm not going to consider that in any way.
Thank you.
I'm not going to consider that he went to trial, he pled not guilty and went to trial, that's his right. And if anyone punishes someone for exercising a constitutional right, then it's no constitutional right at all. Likewise, he chose to, basically, he didn't express remorse or lack of remorse. I think he did express empathy for the family, for the victim in this case. However, insofar as any lack of remorse or going to trial, I'm not going to consider that against him.
Doesn't show remorse.
So, okay.
Yes, Your Honor.
Okay.
I'll just bypass the legal argument.
Well, I don't want to cut you off. I just wanted to tell you I'm not going to consider that at all.
No, that's fine. It was for the purpose of Mr. Ball not giving a statement, but I'll let the state go ahead. It's fine.
Okay, all right, Mr. Locondro, on sentencing, what I do need to do is I want to make sure everybody's on the same sheet of music about the verdict. Count one obviously is a capital felony,
Right,
punishable by mandatory life in prison.
correct.
So I have no discretion but to impose a life sentence without the possibility of parole in that count. But count two, attempted first-degree murder with a firearm, my research indicates that's a life felony.
Correct, it's punishable by life with a 25-year minimum.
Okay, do you agree, Ms. Early, that that is a life felony?
Yes, with the minimum, yes.
Okay. With a minimum of 25 years, right?
Correct.
Okay. And then count three is pretty easy, secondary felony punishable by up to 15 years.
Right,
Everybody agree with that?
yes.
All right. Now, attempted first-degree murder with a firearm, as far as verdicts count 4, 5, 6, and 7, that's also life felonies?
Correct.
Everybody agree?
Yes.
Just like count 2 was?
Right, with the same minimum.
All right, so with a minimum of 25
25.
years. So that would be 4, 5, 6, and 7. Count 8, everybody agree that's a secondary felony punishable by up to 15 years.
Correct.
Yes.
And count 9, third-degree felony punishable by up to 5 years?
No, it's actually a first-degree felony in this instance because it was a,
Tampering with,
Oh, got it.
tied to
First-degree
the first
felony?
degree.
sorry, it's punishable by up to life because because the tampering occurred on a charge that's mandatory life. So it's punishable by up to life.
Well-
It's a 30-year felony.
It's a first-degree?
It's a first-degree felony, but it actually is punishable by up to life.
Do you agree with that?
I agree,
Okay.
since it's attached to a
So it's a
first-degree felony.
first-degree PBL?
Correct.
Okay. All right. Okay, now, Mr. Locondro.
Yes, Your Honor. Briefly, I would ask for, obviously, in count one, it's mandatory life, so that a life sentence be imposed. And then for all of the attempted murders in the first degree, I would ask for concurrent life sentences with 25-year minimums. For counts 3 and 8, which are the shooting deadly missiles, I'd ask for the...
One time. You said 25-year minimum. Isn't that a floor? Because
Correct.
it's not 25 years for 1020 life. There's no 1020 life requirement. So when you say minimum 25 years, isn't that the floor?
That's the
Below
floor.
which I cannot go.
Right, correct. So then, right, so I'd ask for life on all those attempted murders. And then for the shooting deadly missiles, I'd ask for 15 years. And then for each. And then for the tampering, I'd ask for 5 years in prison.
5 years in prison?
Right.
Okay.
And I'd ask, I think that the court has the discretion to actually run them consecutive to one another, meaning the events of the March 19th could be run consecutive to the events that occurred on March 17th, as well as the tampering. I'll leave that to the court's discretion, but I think the court could do that if it chose to.
Is there any thing in the statute, on the tampering statute, that would require me to impose a consecutive, or may I exercise my discretion and impose a concurrent
I
sentence?
think
It's a discretion of the court. Well, you can answer.
yes, it's discretionary. And then I have.
You know, some statutes, like escape, for instance, require that any sentence of escape be
Right.
consecutive. So there's nothing, as far as you know, in the statute, there's nothing in the statute that would require me to do that.
Not that I'm aware of, no.
Okay, and you agree with that, Ms. Early?
Agreed, Your Honor.
Okay,
And then, Your Honor, I have, as I told you, I have to catch a flight. Ms. Rivera is going to take over for me moving forward.
very well.
Okay, thank you.
All right. Okay, have you, by the way, Ms. Early, before you start, have you taken a look at the score sheet in this case?
I don't believe I got the most recent score sheet.
Okay, I don't think it's right, because it says murders, capital felony, it's PBL, it's not, it's capital felony. Also, I'm not sure that a capital felony should be scored on the score sheet.
I just scored it with, like, that's how I've
I
understood it,
didn't-
is that if it's life, you're just supposed to put
I
life.
didn't get a copy.
So that's how I did it, but I can send a copy, or she can look at it.
Ms. Jenkins, could you give Ms. Early a copy? I don't
We'll certainly correct it.
I don't think the guidelines are correct, because I don't think you score a capital felony, number one.
First one, that's the PBO.
And
It's not supposed to go
capital
on.
felony, not a PBL. Again, we've got a situation where we've got a mandatory offense. Ms. Rivera, I'm sure, can handle that.
This is not
Like I say, if I'm not mistaken, I think capital felonies are not scored at all. That's correct. And then so that the guideline score sheet needs to be corrected. All right, Ms. Early, and I'll let you work on that, Mr. Rivera. Ms. Early, I'll hear you on sentencing.
Well, to echo the sentiments of Mr. Ball, since his arrest, he's maintained his innocence. I am not going to speak on the jury's verdict, that it's for the Court of Appeals, but based on his sentiments of what he expressed to the court regarding the maximum for the violation of probation, I don't believe Mr. Ball feels that the court, or would like the court rather, to take into consideration some form of mitigation in the evidence. The court believed that, and I'll go backwards for count 9, that it was a close call when you dealt with the tampering case, and the court reserved ruling for after the verdict. Based on his continuous belief and maintaining his innocence throughout the duration of trial and even up to the verdict, there won't be any additional mitigation from Mr. Ball. Based on the counts, I do know that the court does not have discretion on count 1, but regarding count 2, the 25 minimum mandatory, we would ask the court to sentence Mr. Ball on the floor, the minimum. The minimum for his YO was the 3-year minimum mandatory, and the court sentenced him to the 30 years. I would ask the court to take into consideration not only who Mr. Ball is, but based on the evidence that the court had the opportunity to listen to. Count 2 would be the 25 minimum. Count 3, we would ask the court 15-year minimum. Counts 4 through 7, 4, 5, 6, 7, the 25-year minimum, considering the court has no discretion to go below that. Count 8, the 15-year minimum, and count 9, the 5-year minimum, with the understanding that there was some testimony and the court had a close call regarding count 9. We would ask the court to run all of the charges and counts concurrent as opposed to consecutive, and run the 2017 and 2018 concurrent with the 2021 case. The minimum for counts 2 through 9 to run concurrent with 2017 and 2018, based on Mr. Ball's position that he has maintained his innocence.
Do you think that residual doubt, even if I were to have any, is a proper sentencing consideration?
I'm sorry?
Do you think residual doubt is something that I can properly consider in sentencing, even if I had any?
What the court can consider is the rule of law. And considering, and I know this would be moot, the sentencing would be moot if the court by chance, based on the case law, the motion for due trial. So that, putting that argument aside, the court reserved ruling on the second judgment of acquittal for count 9. And based on it being such a close call, not to go back again on the jury's verdict, but I do believe that being such a close call, taking out the tampering, would have basically let the chips fall on the case, the state's case in chief, as well as the state's rebuttal. In addition to that, the court can take...
I totally understand what you just said, let the chips fall. If the court would have granted a judgment of acquittal on count 9, how would that affected the evidence on any of the other counts?
Of course, it would be the defense position. Obviously, we would not know, but the argument would then, it would weaken the state's case, because without count 9, it was, first of all, it was extremely prejudicial when you think about the evidence that it took to prove count 9. But without count 9, there was no tampering with the state star witness, where he claimed he identified initially Mr. Ball, but then he said it several times under oath on a sworn deposition, not with Mr. Ball's counsel, but actually Xavier Porter's counsel, that he was not the shooter. So the tampering kind of puts it in the jury's mind that
What he testified to was he didn't know who the shooter was. He didn't say Mr. Ball was. I don't remember him saying Mr. Ball wasn't the shooter. What I remember him saying is, I don't know who the shooter is.
Well, to answer the court's question, the very last question I asked Mr. Poe was, could you identify, and I pointed to Mr. Ball dramatically, but could you identify Mr. Ball as a shooter? There was a long pause, and he said no. The tampering, considering it was so close, that, when I say would let the chips fall, or it would dismantle the state's case, because with the tampering, you give the jury the ability to assume, based on the evidence or applied to the evidence, that his testimony of whether or not he's the shooter was tampered with. Without that tampering charge, or even with the severance that, again, the state, Your Honor, denied, and again, that goes up on appeal, that was extremely prejudicial. There's no way that the state of Florida could prove that Mr. Ball was a shooter if they just would have charged him with counts 1 and 2. There was nothing connecting him.
Here's the problem is, I understand what you're saying, but the thing is that that evidence would have been likely admissible as Williams rule evidence, because the DNA on the gun light at the shooting that happened 18 hours before in the matching shell casings were certainly relevant to identity and would have been Williams rule had it not been separately charged, most likely admissible under the Williams rule. And so I hear what you're saying, but I don't necessarily agree that that it was severely prejudicial, because the jury would have heard that evidence under Williams rule had these charges not been filed.
Yeah, that would be the second argument. The strongest argument is really the tampering. But the court can take into consideration, again, the Mr. Ball's consistently maintaining his innocence in this case. I understand that there was a record, but as his sister presented to the court, he's more than the defendant that you see before him. I would just ask the court to utilize the court's discretion, run all of the counts concurrent as opposed to consecutive, the minimum on each of the counts as opposed to the maximum, and run it concurrent with the 2 VOPs.
Okay, very well. Anything else, Ms. Rowland?
Nothing further.
Thank you. So I need an updated score sheet.
Yes, Your Honor, I updated the score sheet, and he scores 313.5 months, not factoring in the capital.
All right, can we get it printed out?
Yeah, I'm just typing it right now to fix it, but that would be the total guidelines.
Okay. 313 months?
313.05 months.
Okay.
For the state.
I'm going to just take a pause here, recess in place until we get that out, so Ms. Early can take a look at it. Okay, that's what it is 26.0875
Years, yes.
years, if that is accurate. And everybody agrees count 9 is a first degree felony punishable by life because of the tampering involved a capital felony? Is that, or is it first degree felony? I just want to make sure. Somebody said that it was punishable.
Which one, Your Honor?
Count 9,
I have it as a first degree felony because it's attached to the first degree count 1.
so the maximum is 30 years?
Well, it enhances it, so it would be punishable by life.
It's typically a first degree felony. Oh, no, okay, I guess what I'll do is, let me take, so I'm not sure.
I have it as a first degree felony, Your Honor. I don't know if I'm.
Okay, well, the state says it's a first degree felony punishable by life, so I guess I need to take a look at it.
Yes, so it would be under 9.4.2.
Okay, so here's how I read it. So I'm looking at 914.22, Florida statutes, 2E. So the state charged this sort of in the alternative, harass or so tampering with a victim is, when it involves a capital felony, is a life felony. Harassing a victim when the prosecution is for a capital felony is a felony of the first degree, punishable by life. So tampering is a life felony. Harassing is a first degree punishable by life. And it appears that, and I'm taking a look at it right now, that the state basically charged in the alternative, because harassing and or tampering.
Yes, Your
All right, in any event, we agree it's punishable by life. All right, so where are we at on the,
Honor. Your Honor, I apologize, I was looking at the statute, I'm wrapping up.
okay.
Your Honor, I had to factor in the violation of probation cases, so the most updated guidelines, and I'll send a copy to the investigating email if that's okay, and the clerk would be, would be 344.1 months.
Okay. Let me ask the question, state the question. Would the state have any objection to me imposing a sentence on the shooting deadly missiles and the tampering to a sentence that does not exceed the statutory maximum?
No objections to that.
Okay.
Please. No, wait, I'm gonna resend them. Okay, this one. These are, that way.
Did you get it?
I did.
Thank you. Okay, let's go back on the record. Ms. Hurley, let me know when you're ready.
I'm ready, Your Honor.
All right, very well. Okay, so, Madam Clerk, court costs, is there court costs just the normal?
Just a normal 518 for developed PDF.
Okay.
That is me.
All right, so as to counts 1, 2, 3, 4, 5, 6, 7, 8, and 9, I'm going to adjudicate you guilty. As to count 1, pursuant to law, they sentence you to life in prison without the possibility of parole. As to count 2, attempted murder in the first degree with a firearm, a life felony, I sentence you to 40 years in the Florida Department of Corrections. As to count 3, shooting and throwing deadly missiles, I sentence you to 15 years in the Florida Department of Corrections. As to count 4, I sentence you to 40 years in the Florida Department of Corrections. As to count 5, I sentence you to 40 years in the Florida Department of Corrections. As to count 6, I sentence you to 40 years in the Florida Department of Corrections. As to count 7, I sentence you to 40 years in the Florida Department of Corrections. As to count 8, I sentence you to 15 years in the Florida Department of Corrections. As to count 9, I sentence you to 1,473 days in the Florida Department of Corrections. I will run the sentences in counts 1 through 9 concurrently with each other. I will give you 1,473 days credit. I will run the sentences that I just imposed in 2021 CF 837. And this sentencing is happening all in the same sentencing proceeding. I imposed sentence earlier in the probation cases simply because both counsel advised me there were no additional sentencing arguments. And then I'm imposing sentence now after her victim impact statement, testimony from Mr. Ball's sister in this case, but it nevertheless is occurring in the same proceeding. So I'm going to run the sentence that I just imposed in 2021 CF 837 concurrently with the sentences I imposed in 2017 11673 and 2018 CF 320. So I'm running them at the same time. So that is not to impose additional time on the probation violations. Well, that has the effect of it, presuming that the convictions in the instant case are not disturbed or overturned. $518 in court costs.
Last thing you said, I'm sorry.
I beg your pardon?
The last thing you said for the...
I said that the effect of me running them concurrently is that I'm not giving Mr. Ball additional time on the probation violation because I'm running those sentences concurrently with the sentences imposed in this case, which will have the effect, unless these convictions and sentences are overturned, of him not serving additional time. So I'm running them concurrently. $518 in court costs plus $50 application fee. I'll convert that to a civil judgment. And I just want to make clear on the record regarding the earlier violation of probation proceedings that the court based its findings at the state board's burden of proof by more than a preponderance of the evidence based on the court's analysis and weighing of the evidence. Because that's, as a judge in violation of probation, I sit as a finder of fact, and so that's based on my independent evaluation of the evidence in the 2021 CF 837 case. All right, so Mr. Ball, you have 30 days to file a notice of appeal from the date I rule on the motion for new trial. If you cannot afford an attorney for the purposes of appeal, I will appoint one for you. If the defense were to file a premature notice of appeal, given that the motion for new trial has been filed, I still will have jurisdiction to rule on that. And as I say, I won't press your time. I'll make sure that I rule on that before next Friday, or Friday at the latest, a week from Friday at the latest. I will file that week from today. Okay? All right, so I've imposed the sentences. I'm running them all concurrently with each other, and then, as I say, concurrently with the 2 probation cases. I've given credit for the 1,473 days time served against the defendant's sentences in this case. Credit was granted to the probation cases, part of which will be calculated by the Florida Department of Corrections pursuant to statute. All court costs, fines, fees, surcharges have been reduced to a civil judgment. I've given the defendant his appellate rights, advising him he has 30 days to file a notice of appeal, and that I'll appoint counsel for him if he would like me to appoint counsel. Of course, retained counsel is responsible for directions to the clerk and to the court reporter and ensuring the appeal is perfected. If you don't, if there's no appointed counsel to follow for appeal. Do you agree with that, Ms. Owen?
I do. I'm going to follow up with Ms. Jenkins. I discussed it with the senator.
Okay.
So good. Keep it on it.
All right, so I think it's, so as we know, trial counsel is responsible for perfecting the appeal, and then if the defendant is represented later by counsel from the public defender's office is down in the Seventh Circuit, but it's trial counsel's responsibility for withdrawing, if applicable, to ensure that the record on appeal is prepared correctly, and also the appeal is perfected prior to being passed on. Okay? Any other questions? Anything else that you would like to bring up? Nothing, anything from the state?
Nothing from the state.
All right, thank you, everyone. I appreciate everyone during this difficult time, and court is adjourned.
Can you give me just a couple minutes? You take this back? Yeah.